Ms. Holmes on Christina Rodriguez, Ms. French. Good morning, ma'am. Are you Christina Rodriguez?
Good morning.
And this is 17-27256. Ms. Rodriguez is on probation for injury to a child, elderly or disabled individual. There's a motion to revoke that's been filed. There was a request for a competency evaluation. I'm going to take judicial notice of the court's file. Ms. Rodriguez was evaluated by Dr. Rapon. I've got that report dated June 22nd of 2026. The finding in that report is that Ms. Rodriguez is currently competent to stand trial. And so is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
Then at this time, based on that report, I will find Ms. Rodriguez competent. And where are y'all on the case and what's the announcement?
If we could do probably a couple more, it's more than likely this may need to lead up to a hearing. From our conversations with Ms. Rodriguez, she doesn't believe she's committed the alleged allegations.
Okay. So you want just a couple of weeks, and then that way, if we're gonna have a hearing, we need to go through the motion.
Yeah.
It's still gonna get pushed back. So let's just do maybe a 2-week
That's
reset.
fine.
Okay, we'll reset at 2 weeks. Ms. Rodriguez, Ms. Holmes will be out there to visit with you about your options, and then with the next court date, we'll get pleas of true or not true, and then see where we go from there.
Yes, ma'am.
Okay, you can go back with the bailiff.
Brittany, I won't be here that week, but it's okay. I'll let somebody else take those, please, and then we're up from there.
I think it's. Mr. Wilkerson, you've got Kevin Thomas.
Here's Connor. Hey, that's the one that was on the list. Yes. That's correct.
Morning.
Morning. This is.
Morning, Ms. Malfino. Good morning, sir. Are you Kevin Thomas?
Yes.
And this is 26 DCCR 0798. Mr. Thomas is charged with assault on a security officer. Mr. Wilkerson, what is the announcement?
Your Honor, Mr. Thomas would like to proceed to trial on his case based on the underlying facts of the incident. I anticipate filing a notice of affirmative defense. And so I will get that filed. I've also got a HIPAA release that Mr. Thomas has signed. I do need to, some time for those subpoenas to come back. So
there was already a plea bargain rejection. It looks like that was signed, June 16th, with a rejection of 15 years. Any change in that offer?
Yes, Judge, I have inherited this case from Mr. Coleman. I put a note to myself, see if Mr. Wilkerson and I speak in lieu of some notes that Mr. Coleman left before he switched courts. Before he maybe jumps through all of those hoops with those subpoenas. I understand where he's going. I think I'm probably going the same direction. Maybe one more setting before we were to place it on the trial docket. Let him get those in the works.
Sure, let's do
might be
that.
Productive.
Get with Ms. Malfino now that she's on that case, see if there's any new negotiations. Go over that with Mr. Thomas, and we'll, if it needs to be on a trial, we'll put it on at the next court date.
yeah, Your Honor.
Okay, all right, you go back with the bailiff. Then you got Javian Blunt.
Yes, sir.
Javian Blunt.
Good morning, are you Javian Blunt? And this is cause number 26 DCCR 1220. Mr. Blunt is charged with murder in that case. Mr. Wilkerson has filed a motion asking that I reduce the bond, which is currently set at $1.5 million. And Mr. Wilkerson, you may proceed.
Yes, Your Honor. This case, Mr. Blunt has been incarcerated now since March. And with regard to his case, we are still missing evidence, in terms of the, whether or not well, let me put it this way, the person named in the indictment, is apparently an alias of the actual victim. And so, the concern at this point is, uh, in part, a primary concern is whether or not the state could sustain a conviction as the indictment is presently worded. Um, that being said, Judge, a $1.5 million bond does not meaningfully give Mr. Blunt the opportunity to secure bail in this case. And so, in being reasonable with the bond reduction request, given the standard bonds for offenses of this nature, we believe a bond of $750,000 would adequately secure the defendant's appearance in court.
I need some, Mr. Blunt, raise your right hand, please, the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right.
Mr. Blunt, state your name for the record, please.
Jamie Blunt.
You presently working?
No,
Oh, well, obviously, you are presently incarcerated in Jefferson County Jail, correct? Are you able to raise funds, either by borrowing or disposing of assets, to make bond in the present amount of $1.5 million? Do you believe that with the help of family and potentially friends, if the court were to reduce bail in this case, that possibility might be enhanced?
yes, sir.
Can you describe to the court your familiarity with the area? That is, do you have family here in Jefferson County?
Yes, sir.
Are you from this area?
Yes, sir.
And have you been in Jefferson County for the last 5 years?
Yes, sir. I'm in my life.
All your life? Ever moved away?
Speak up, please.
No, sir.
Prior to becoming incarcerated, were you working?
And for not right before, I had just not working in the Ford Arena,
Okay. How long had you been there?
few months.
Are you asking this court in the interest of justice to reduce your bond from the 1.5 million that is presently set at?
Yes, sir.
Pass the witness, Sherman.
No questions or service.
All right, any other witnesses?
No, Your Honor.
Mr. Smith, any witnesses?
No, Judge.
What is the state's position?
State is opposed to a bond reduction, Judge. It's not uncommon that bonds in murder cases are set at $1 million.
I need you to speak up too.
It's not uncommon in this court and in Jefferson County that cases for murder with facts such as these are set at $1 million for her.
So
Like that's a sufficient bond in this case.
do you want me to take judicial notice of anything?
The affidavit of probable cause would be.
Okay, I'll take judicial notice of the court's file, including the affidavit of probable cause. Give me just a second to get that. All right, anything else?
Nothing from the defense, Your Honor.
Also, the jail records show he has disrespect for the staff and other inmates in jail while he's been.
I'll take judicial notice of, I just received a jail incident report. Has two incident reports on it from July 15th and July 9th.
And I would just note, Your Honor, that both of them involve minor infractions. It looks like being out of bunk after lights out.
Right, this time I'm going to grant the motion to reduce the bond. I'm going to reduce the bond to $1 million. There will be bond conditions of house arrest, as well as wearing a GPS monitoring device if that bond is made. All right, we can go back with the bailiff.
Thank you, Your Honor. I believe that concludes my cases until the 11 a.m.
Thank you.
Excuse me.
Yes, sir. Ms. DeLajon, Howard Walker. Yes, Your Honor. Morning. Morning.
Morning.
Good morning. Good morning. Are you Howard Dwayne Walker Jr.?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
It will, Your Honor.
Mr. Walker, in clause number 26, DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
yes,
I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. DeLage?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Walker's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you in accordance with your agreement to a term of 22 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. DeLage. And Ms. DeLage, do you have your discovery certification?
The cert, I don't have the discovery sheet yet. I was gonna email it this afternoon. Didn't expect to get a plea today.
Yeah, if you'll get that done as quickly as
Yes.
possible, and because the case has to get closed out,
Right.
then it becomes, you won't be able to get to it.
Yes, ma'am.
Okay, you can go back with the bailiff.
Thank you.
Do you want to take these?
But that's what's alleged is that and how.
Thank you.
Thank you,
And
Nancy.
may I excuse?
Yes, thank you. And Mr. Parker, you've got Gabriel Cruz.
Ma'am.
Good morning. And I've got, two and a dismissal on one, is that right?
Sheriff, why'd you let me do that?
He said, what'd you do? I said, I came over here, I had to just on the page.
I knew you did, Mr. Bishop.
I was trying to get him.
I mean, I thought about it.
I didn't even look. I still think back to the day when the Boston Times walked in here on it.
Oh, yeah. Yeah. Good morning. Are you Gabriel Cruz the third?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
0373 and 0374.
Mr. Cruz, in cause number 26 DCCR 0373, you're charged with a third-degree felony offense of stalking from February 23rd of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you actually did what they charged you with?
yes.
And then in cause number 26 DCCR 0374, you're charged with a third-degree felony offense of violating a protective or bond order, and that's from February 23rd of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreements that you've reached are for 10-year term in prison on each of these cases, but that would be probated for 10 years. There would be a $500 fine in each case. There would be a dismissal in cause number 26 DCCR 1060. And you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Cruz is not competent?
No, Your Honor.
And Mr. Cruz, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State, sorry, we already did that. All right, I'm going to find, Mr. Cruz, that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for sentencing so that we can get a pre-sentence report that'll give me more information about you and your cases, and then we'll come back later for sentencing. All right, you can go back with the bailiff.
Several defendants entered this American courtroom, and each case brought a completely different legal battle. First was Cristina Rodriguez, who is currently on probation in a case involving injury to a child, elderly person, or disabled individual. A motion has been filed to revoke her probation, but before the case could continue, the court had to determine whether she was mentally competent. After reviewing a professional evaluation, the judge officially found Rodriguez competent to stand trial. However, she reportedly denies committing the alleged probation violations. The judge gave her attorney 2 more weeks to discuss the available options. At the next hearing, Rodriguez will likely be required to enter a plea of true or not true. Next came Kevin Thomas, who is charged with assaulting a security officer. Thomas previously rejected a 15-year plea offer and now wants to take his case to trial. His attorney plans to present an affirmative defense and requested additional time to collect medical records and other important evidence. The prosecution indicated that new plea negotiations may still be possible before the case is officially placed on the trial docket. Rejecting a plea offer is always a serious risk because a defendant may receive a better result at trial, but could also face a much harsher punishment if convicted. The courtroom then turned to Javian Blunt, who is charged with murder and was being held on a $1.5 million bond. His attorney argued that the victim's name listed in the indictment may actually be an alias. The defense also claimed that the extremely high bond gave Blunt no realistic opportunity to secure his release. The prosecution opposed any reduction and pointed to the seriousness of the murder charge, along with 2 minor jail incident reports. After reviewing both sides, the judge partially granted the request and reduced the bond to $1 million. However, even if Blunt posts the bond, he must remain under house arrest and wear a GPS monitoring device. A bond reduction does not prove innocence. It only determines whether the defendant may wait for trial outside jail. Next, Howard Dwayne Walker Jr. pleaded guilty to first-degree injury to a child. The judge confirmed that his plea was voluntary and that he understood the consequences. Walker was sentenced under the plea agreement to 22 years in prison and gave up his right to appeal. Finally, Gabriel Cruz III pleaded guilty to stalking and violating a protective or bond order. His proposed agreement includes 2 10-year sentences, both probated for 10 years, along with fines and strict probation conditions. The judge delayed final sentencing until a pre-sentence report could provide more details. In one courtroom session, the judge handled competency questions, rejected plea deals, a murder bond hearing, a lengthy prison sentence, and possible probation, showing how quickly a single court appearance can change a person's entire future.